So I'd like to talk to you in this segment about how we actually charge for the services. Well, we have a number of services and they're all outlined on our website, but in a very basic way it operates like this. We always commence with inviting you to come in and speak to us first. And that first conference we never charge for, it's entirely free and there's no time limit on it. We do that and we offer that because we know how important it is. Before we go ahead with anything with you and before you can make a decision, you need to come and meet us, form an impression about us, ask all your questions, and we need to answer them properly and fully, and explain to you precisely how we would manage your dispute, and convince you through that discussion that it's the better way to go. If there are special issues that come up and we think that, well, this service is not suitable for you right now for this early management, early resolution, we'll tell you. If we think that you need to get particular legal advice first, we'll tell you. We'll also explain to you what's involved to get the other party or parties to dispute to come in as well and give you some idea of how you can do that, because we can't do that for you. We can't approach the other party in dispute on your behalf and invite them in, because we must be kept in a neutral stance. The other thing to be understood here is that our preference is always to work with both sides of the dispute together and stay in a neutral capacity. But that doesn't always happen. And so should it turn out that the other party won't cooperate and come on board with you, we offer services where we can act for you individually, and we become retained as your representative. And I mean here as a legal representative. We'll explain to you how we can do that. But if we do act for you in that way, we'll still be doing everything that we can to help you resolve your dispute early. It's just that we'll be acting for you individually as opposed to being in a neutral capacity, acting for both sides of the dispute in total impartial way. Now, the cost is structured in this way. There's work to be done at the beginning and there's an hourly rate. And the hourly rate that we charge for anything that happens in that early phase before even going to a mediation will somewhere lie between $330 an hour with GST to about $440 an hour with GST. Where the hourly rate that we select at the end of the day depends on a number of factors, and that will all be explained to you in that first meeting. And some disputes, just by their nature and the amount of money involved and so on, or other limiting factors, will attract a lower rate. Other ones will attract the higher rate, and other ones in between. So we will also give you, based on when we fully understand the dispute, having talked to you and the others, we'll map out for you what the steps are along the way. So it'll be stage 1 doing this, stage 2 doing that, then leading up to the mediation. We'll describe the work that is to be done in each of those stages, the estimate of cost. And that will all go into the dispute resolution agreement that is eventually signed. If the matter proceeds to the point where it does require mediation, that mediation might be a half-day mediation, it might be a full-day mediation, it may even require more than a full day. The fees that we will charge for those are again on the website, but they would fall into this normal range. A full-day mediation will usually cost somewhere around $3,300 with GST included, and a half-day around half of that. But everything is tailor-made. Everything is bespoke, and that is worked out in the first conference. And then whatever the agreement is, that's what's in the mediation or dispute resolution agreement that you sign. Now, there's something that we do at Commercial Disputes Management Center that is very, very important to explain to you about charging for services. And this is one of the things I think that makes us somewhat unique in the marketplace. We recognize that what's anathema for most business owners and businesses in having anyone assist them with their dispute is for the work to be done and the cost to be paid being uncertain and open-ended. So that you're placed in a position where if you come on board with the service provider, that you really don't know how much it's going to cost you, you don't know how long it's going to take, and, but all you know is it's going to be expensive. And that's a considerable worry for many, many business owners. So we want to tackle that head on, and we do. So when you come and discuss with us, what we will discuss with you is if you can bring your dispute to us with the other party involved and you're both committed to the process, we can offer you certain things that would otherwise not be available to you if you would head off into court or if you were engaging us simply on a retainer to be your representative as against the other party in the dispute. And those are two main things. One is, in most cases, in those stages of pre-mediation work and mediation work, we are pretty confident to be able to quote you a total lump sum fee for the pre-mediation work and for the mediation. So you can have absolute certainty as to what the cost will be. You can measure it up, you can discuss it with the others and decide how you're going to divide that up and how you're going to cover it collectively. So there's total clarity, total certainty for you there. The other thing is this. If we have a dispute where everyone involved, all the critical people to resolve that dispute are willing to come on board and work cooperatively, collectively, collaboratively with our assistance to achieve early management, early resolution of the dispute. We are so convinced in those situations about the probability of success in resolving that dispute to everyone's satisfaction that we're willing to work on pay-on-success terms. You only pay us if that dispute is successfully resolved. If for whatever reason it doesn't get over the line, either at the first attempt or the second attempt, but it reaches the point where defeat's staring you in the face and it's not resolved, you don't pay $1. Now, there are certain conditions that attach to that because we have to be satisfied as to certain things. We have to be satisfied that there is a genuine commitment by everyone involved and that everyone that needs to be involved will be involved. And there's no spanner in the works somewhere there that might torpedo our efforts. If we're satisfied about those things, we're very happy to offer that pay-on-success, those pay-on-success terms to our clients. As far as I'm aware, I don't know anyone else who's doing that out there. And that simply demonstrates how confident we are in the way that we can work with people who are willing to work within our protocol, to work within our system, in good faith with each other, and with common intent to choose this way rather than litigation, and to get the dispute over as quickly as possible, get back to business as quickly as possible, to be able to offer those pay-on results or pay-on success terms. One thing before I finish up on this particular segment is to make this clear. What is success? It begs the question, what's success? How do you determine when there's been success? How do you determine when there's been a successful result? Well, this has to be carefully discussed and then defined and spelled out in the agreement. So there's no ambiguity about it, no lack of certainty. So that both you and we will know when the definition that we've agreed on for successful outcomes, successful results has been met. If it is met, then our full fee, as stated in the agreement, will be payable. If it's not, and all genuine, sincere efforts have been made to resolve the dispute and it hasn't been resolved successfully, then no one will pay for the services provided.